20 minutes on the subject of changing experts. You may ask yourself why this is an appropriate subject to talk about in commercial litigation. Two reasons for that. One, it's an area that frequently crops up in litigation. There's not a huge amount of recent authority, and it's one of these subjects, not least given it's a case management decision that is neither black nor white, so I thought it was a useful opportunity to give some guidance on it. The second reason was a more personal reason, and it was to do with an appeal I was appearing in last week in the High Court. So when I was asked to present this talk back in the summer, the appeal was listed last week. I thought, somewhat optimistically, it turns out to be that the appeal would be a roaring success. I could stand here and talk for 20 minutes about how it was a success, give some new guidance that had came from the High Court, and highlight how right I was to appeal that decision. Alas, those of you who have read the notes, and as those of you who haven't are about to discover, the appeal was not a roaring success. I lost. Not only did I lose, there was frankly nothing new to come out of that case to talk about other than the judge to say it was a case management decision, and it's embarrassing to spend any more time on it. So I will stick to the authorities where I didn't appear in to give you some useful guidance rather than the ones that I did. Right, that's the why. Now the what, if I can get this machine to work. There we go. The key areas of this talk in 20 minutes are the rules relating to experts, expert shopping, what it is, when to spot it, what to do about it, and finally, circumstances that are likely to justify a party changing their expert, particularly late in the day. The notes of the talk appear at page 98 in your bundles. They are for reference purposes only. I'm not intending to simply read through them or regurgitate them. And having listened to Andrew Francis say that he's prepared notes or given a talk on a similar subject, were I to choose between the two, I know which one of these I would be putting in my fire to heat, and they're not likely to come from the New Law Journal. Underlying this subject is, of course, the main issue of why would a party want to change their expert, given that there's no mandatory guidance on who to choose as your expert, provided they are suitably qualified. The underlying theme here is, and the key issue is, of course, what happens when you've instructed an expert in litigation, you're midway through the litigation process, and they've changed their mind and ultimately performed that dreaded U-turn, which our current government is a big fan of. I suspect we've all had that sinking feeling, having read the most comprehensive and supportive expert report that agrees with every single one of our items in the claim form, or alternatively in the defence. We've confidently advised our client that we're going to succeed and the claim is going to be a success, and then to sit down either in conference or after the experts get together and have a joint settlement meeting, only to realise that in person they're not as convincing as they are in paper, and they don't really stand up to any scrutiny at all. The question then is what to do. Worst, when they perform a complete U-turn in their entire opinion, roll back on everything they say and undermine your case in its entirety, or even on occasion when experts are either dismissed from their employment that gives rise to their expertise, or discredited entirely, that you have no confidence in them. It is surprising how much these matters do arise, and the talk really seeks to give some guidance on what you as a litigator can do when that happens, when you're likely to succeed in changing an expert, and when you're less likely to do so. The starting point on any application in commercial litigation is, of course, the rules, and dull as they are when it comes to experts, we do have to cover them briefly. And in particular, everyone in this room will know that the rules relating to experts are governed by Part 35 in the CPR, but in particular draw attention to Rule 35.1 and the two important points that come out there. Firstly, expert evidence shall be restricted to what is reasonably required to resolve the proceedings. Well, the court is under a duty to restrict expert evidence. The second point is what is reasonably required to resolve the proceedings shows that in exercising that duty, the court does have a fair amount of discretion and leeway, combined with the fact that any application to change an expert is likely to, it will be a case management decision and is likely to afford the judge dealing with that also a degree of discretion. I also point out to that phrase, resolve the proceedings. This is often forgotten about, but there is a crucial distinction between an expert being appointed to resolve the proceedings in a case and an expert being appointed to support a party's case. That is not what they are there for. They are there to assist the court in resolving proceedings. In line with the rules, we also have the guidance, and I flag up in the notes the different approaches that the courts take in an application to apply for additional expert or in an application to apply to change your expert, and the former is certainly easier to secure than the latter. The key point when applying for additional expert is the court wants to know, or the court will be examining, is there a good reason for the lateness in the application? And when I refer to applying for additional expert evidence, what I'm really talking about here is after the CMC stage or after the CCMC, when the parties have agreed how the case is going to be managed, the court has set down directions, and then a party, for whatever reason, decides in fact they need more expert evidence to cover certain points that either haven't been covered originally or have transpired in the course of the litigation. The key factors in that application are firstly, is there a good reason for the lateness of it? Secondly, is the new evidence significant? Thirdly, what is the prejudice to the other side? And fourthly, and arguably most importantly, what is the justice to the case in line with the court's objective of achieving proportionality? Really, in applying for additional expert at a late stage in the proceedings, the court is asking you, why are you applying for this now and not sooner? Contrast that with applying to change your expert. And the key question the court is asking itself and asking you when you're making that application is, why are you doing it at all? Why are you making this application? Why do you need to change your expert now, given you chose as a party who your expert was to be in the first place? And the reason for that issue and the reason for that test, which is undoubtedly more stringent, is the court's deterrence against expert shopping. Expert shopping is one of those phrases that everyone in litigation will undoubtedly have heard at least once. It's bandied about quite frequently, but the precise definition isn't always that clear, albeit it seems fairly obvious. Expert shopping comprises two main factors. Firstly, where a party is seeking further, more often than not, different expert evidence, but also where it's seeking to suppress the expert evidence it already has and hasn't been disclosed to the other side. It is effectively seeking to produce or obtain expert evidence that is favourable to its case and favourable to its side, rather than that requirement under 35.1, expert evidence to resolve the proceedings. The main authority the main authority that led to this guidance in expert shopping is the case of Edwards, Tubb and Wetherspoon. That was a PI claim involving someone falling at work, undoubtedly a Wetherspoon's pub, where they suffered a serious injury. And ultimately, the application that led to that authority wasn't to change an expert. The other side, the side who weren't making the application to change the expert, were actually seeking the earlier reports that had been obtained but not disclosed, and the judge in that case granted that application on the basis that there was an obvious inference that the party who was applying to change its expert was doing so for the purposes of expert shopping. If there is a suggestion of expert shopping in a case, the factors that confirm that are set out in the case of Murray and Devonish, as set out by Lord Justice Gross, and they relate to 5 key areas, which are the state of litigation at the time, the reason the party is given for its change of experts, the interests of justice, the candour in which the application is being approached, and the evidence behind it, and finally the risk of losing the trial date. The issue with expert shopping is, aside from the court's deterrence of it and avoiding parties obtaining experts simply to support their case where they see fit, is the consequences of doing so and the consequences of where it is discovered. It doesn't automatically follow in every case of expert shopping that the party who's applying to rely on a new report will be precluded from doing so. However, what is likely to follow from an application or where an inference of expert shopping is found is that the party who's seeking to rely on new expert evidence will be required to disclose the expert evidence that they have and haven't already disclosed. And it's undoubtedly the biggest factor in determining what is to be disclosed. And on the issue of disclosure, one frequent question that arises in this topic of changing an expert is, what in fact as a party are you obliged to disclose when you go off and speak to an expert at any stage, either pre-action or during action? And it's not, I confess, the easiest question to answer, particularly for those starting off. There is, however, a crucial distinction, and as was set out in that Wetherspoon case, and the distinction is this: where a party instructs an expert to advise them on a private basis, they are generally not required to disclose that report because it is privileged. Where a party instructs an expert for the purpose of proceedings, that is inevitably disclosable. Further authority on that point is given in a recent case of Cottesmore Hotel and Eco Top Heat, which is referred to in the notes. That was an interesting case concerning a fire at a relatively posh golf club in Sussex, which was claimed at a value of around £7 million. And the issue was who started the fire. The hotel were blaming the window installer for effectively dropping a cigarette at some point in the hotel. But the expert evidence concerned the fire investigation. The experts attended at the time or very shortly after the fire had been put out. There was a discussion between the two experts, albeit the defendant did not actually prepare a report. At the CCMC, some 2 years later, the defendant sought to rely on a different report than had attended that site at the time. And although the application to rely on that different report wasn't entirely opposed, what the claimant sought wasn't just that early report. Of course, no report had actually been produced, but what they were seeking was the file note between the expert and the solicitors, which would ordinarily, of course, not be disclosable because that's privileged. In this case, the judge ordered its disclosure, holding that it was a high price to pay. There is a meaning of expert shopping. And it was really the extent of expert shopping, whether it's flagrant or not, that will determine what is to be disclosed. More often than not, in a bog standard case, the court will order disclosure of the earlier report that hasn't already. If, however, it's clear that a party is simply applying to change its expert and seeking to suppress either the earlier report or the earlier material, that is likely to be ordered to be disclosed as well. Before actually moving on to what amounts to good reasons and less good reasons when applying to change an expert, it's worth highlighting the effect of CPR 3511. as to the consequences of disclosure, they are not to be underestimated, because when an expert report is disclosed in proceedings, the other side is entitled to rely on it. You do not require an order from the court saying as such. It is provided by CPR 35.11, and by virtue of being entitled to rely on the earlier reports, you're then entitled to rely on that in evidence, ask questions, address it in a joint statements between the experts who are now giving evidence. But on to the final aspect of this talk, what constitutes a good reason when seeking to apply for a new expert or a change of expert in a case, and what doesn't. The first two are fairly obvious, I concede, in that retirement and illness both relate to the unavailability of an expert, assuming, of course, that in either retiring or being ill, they are simply unable or unwilling to come to trial to give the evidence contained within their report. Retirement's not obviously that frequent an issue. It does, however, occur in lengthy litigation. What the courts have emphasised, however, in the authorities that are referred to in the pack in my notes, are two main points. A party does not have an unqualified right to change its expert, and equally, not every application for a change of expert is going to be disallowed, and it's weighing up those two factors as to what, as well as answering the question, what amounts to a good reason that the court is looking at in any application to change. When an expert simply refuses to act, a court is unlikely to resist or dismiss that application, remembering that the issue is, of course, that if an expert refuses to act, they are unlikely to assist the court in resolving the proceedings. The final suggests it's more likely than not to be a good reason is where an expert has been dismissed, or more often than not discredited, and follows from that there is a loss of confidence that a party has in their expert. An example of that is the authority of Lee and Colchester, where the medical expert relied on by a party had been sacked for unknown reasons. And despite the lack of knowledge as to the reasons for his dismissal, the court allowed the party at a relatively late stage to change their expert. Those are the obvious ones. The bad reasons, they're not inherently bad as such. The grey area, it's probably more accurate to describe them, is that issue as we addressed at the start. What happens when an expert's changed its mind? Two authorities referred to Guntrip and Fernandez suggest that is not enough. And in fact, in Guntrip, the Court of Appeal said the mere fact, and they expressed this, the mere fact that an expert has changed their mind is not enough. That is not a good reason. That was reaffirmed in Fernandez. Fernandez was a case that was relatively well publicised when an employee went blind working for Iceland. The Court of Appeal, the High Court emphasised that point and said that, crucially, in Fernandez, the expert had actually given a reason for changing their opinion. They hadn't just made a volte-face. They'd explained that, and that was, despite that, that was not allowed. And the fact that they'd given a reason, the application was not allowed. Contrast that with the authority of Wright and First Group. That was an accident reconstruction expert. This authority is probably to be taken with a pinch of salt, because the application was made a week before the 3-day trial. It was allowed, even though there was very little reason given, aside from the fact that the expert had changed their mind. And the distinction here was there was no explanation by that expert to the change of as to why they had changed their mind. Interestingly, though, the opposing party, the defendant, did get permission to appeal. Unsurprisingly, they managed to agree a settlement before that appeal was. I suspect the Court of Appeal would have taken a different view if it had been heard on appeal. And ultimately, the overriding advice is that your expert changing his mind at any stage in the proceedings, particularly the later, it is unlikely to amount to a good reason. And were this to be determined now by the Court of Appeal, I suspect we would have even stricter guidance. Finally, the summary, to sum up this fairly short talk, 3 main points to take away. 1, any application to change an expert is a case management decision. It adds a degree of uncertainty, and it also removes the prospect of appealing it. So my advice is, if you are going to apply to change, get it right the first time, as I discovered to my cost last week. Second point, which I've finished on, is that the issue of an expert changing their mind is unlikely to justify a change, but the other reasons pertaining to unavailability will support that application. So that gives you some food for thought when discussing with your expert what to do. And finally, the reality is, if an expert changing his mind has left you with no option, the reality is you're going to have to make that application, and the cost of disclosing the earlier reports or the earlier notes that you may have is more often than not going to be a price worth paying. That concludes the talk. Thank you for listening.